Hi students, welcome to lesson number 11, Land Reforms in India. Part A, agricultural land is the most important productive resource in rural areas, and the access to land shapes the rural class structure. Historically, caste and land were linked with each other. Usually, dominant and upper caste had the control over the land, and the lower caste barely had any land. Land, caste and class were intimately linked. Land had a central place in the Indian economy in the past and still holds an important place in it. Historically, land in India was not a private property and was held as a matter of traditional right. Mughal rulers have brought considerable changes in the land ownership pattern. They have imposed monetary tax on the land holdings. However, the land tenure system in modern sense evolved only during the British period. British rule made significant changes in land tenure system, and land was linked to the market for the first time. British introduced three broad systems of land tenure, namely Zamindari System, Ryotwari System and Mahalwari System. However, these three systems were exploitative in nature. The main objectives of this lesson are: number 1, to discuss about the concept of land reforms; number 2, to discuss about the systems of land tenure in pre-independent India; third, to discuss about the objectives and measures initiated as part of land reforms in India; fourth, critical evaluation of the implementation of land reforms in India. Now, let us discuss the systems of land tenure in pre-independent India. At the time of independence, there were three types of land tenure systems prevailing in the country: the Zamindari system, the Mahalwari system and the Ryotwari system. The basic difference in these systems was regarding the mode of payment of land revenue. In the Zamindari system, the land revenue was collected from the farmers by the Zamindars. In the Mahalwari system, by the village headman on behalf of the whole village, while in the Ryotwari system, the land revenue was paid to the state directly by the farmers. In all the three systems, in the usual practice adopted was to get the land cultivated by tenants. Now, let us discuss about the Zamindari system, Mahalwari system and Ryotwari system in detail. Zamindari system. This system was created by the East India Company when in 1793 Lord Cornwallis entered into permanent settlement with landlords with a view to increasing the revenue of the company. Under the settlement, the landlords known as Zamindars were declared full proprietors of large areas of land. In return, the task of collecting rent from the farmers was entrusted to them. The Zamindars were to function as intermediaries between the cultivators and the state. The share of the government in total rent collected by the Zamindars was kept at 10/11, the balance going to the Zamindars as remuneration. At the time of independence, this system was prevalent in West Bengal, Bihar, Orissa, Uttar Pradesh, Andhra Pradesh and Madhya Pradesh. The Zamindari system suffered from a number of defects. It created a unique agrarian structure in the countryside which conferred the right of sharing the products of land without participating personally in the productive process. The system itself was based on exploitation as it conferred unlimited rights on the Zamindars to extract as much rent as they wished. According to Bhavani Sen, approximately 25% of the produce was taken away by the intermediaries in the form of rent. Mahalwari system. This system was introduced by William Bentinck in Agra and Awadh. It was later extended to Madhya Pradesh and Punjab. In this system, the whole village was treated as a unit as far as payment of land revenue is concerned. The responsibility for collecting the land revenue and depositing it in the treasury was the village headman. Then Ryotwari system. This system was initially introduced in Tamil Nadu and was later extended to Maharashtra, Berar, East Punjab, Assam and Coorg. Under this system, the responsibility of paying land revenue to the government was of the cultivator or individual Ryot himself, and there was no intermediary between him and the state. The Ryot had full rights regarding sale, transfer and leasing of land and could not be evicted from the land as long as he paid the land revenue. These rights were not available to cultivators under the Zamindari system. As I said earlier, these land tenure systems were exploitative in nature. In order to bring about the changes in the agrarian structure through direct intervention, land reforms were initiated by the Government of India. Now, let us discuss the objectives of the land reforms in India. As discussed earlier, the Zamindari system was based on exploitation. It created class of Zamindars which did not do any work on land, but snatched away the whatever surplus above the minimum subsistence the cultivator produced. The latter were forced to lead a wretched life of slavery and deprivation. Under the Ryotwari and Mahalwari systems also, the practice of cultivation by tenants became widely prevalent. These tenants were also exploited in a number of ways. Particularly miserable was the condition of tenants at will and subtenants. It was basically to stop the exploitation of the actual tillers of the soil and pass on the ownership of land to them that land reforms were introduced in the post-independence period in India. The government defined the objectives of land reforms as follows. Number 1, to remove such impediments to increase in agricultural production as arise from the agrarian structure inherited from the past. Number 2, to eliminate all forms of exploitation and social injustice within the agrarian system, to provide security for the tiller of soil and assure equality of status and opportunity to all sections of the rural population. Measures contemplated to achieve these objectives were as given below. Number 1, abolition of intermediaries. Number 2, tenancy reforms. Number 3, ceilings on agricultural land holdings. Number 4, reorganization of agriculture. Reorganization of agriculture included the following policies. Number 1, redistribution of land. Number 2, consolidation of landholdings. Number 3, cooperative farming. Now, let us discuss the measures contemplated by the Government of India as part of land reforms. Number 1, abolition of intermediaries. Even before independence, it was widely recognized that the main cause of stagnation in the economy was the stagnation in the agricultural sector, and this stagnation could to large extent be attributed to exploitative agrarian relations. The chief instrument of exploitation was the Zamindar, patronized and promoted by alien government. It was on account of this reason that not only was the desirability of bringing about changes in agrarian relations accepted, but was also adopted as a kingpin of and reform policy. Approximately 57% area of the country was under the Zamindari system on the eve of independence. In some states, legislations were passed for their abolition before 1951. However, most of the work relating to enactment of laws and acquisition of areas was carried out during the period of the first 5-year plan. The official documents claimed that intermediaries were completely abolished by the end of the first 5-year plan. It has been estimated that in all 173 million acres of land was acquired from the intermediaries, and as a consequence about 2 crores tenants were brought into direct relationship with the state. Once the stage of legislation was completed and the stage of implementation started, fresh difficulties had to be faced. Zamindars were not willing to lay down their rights and privileges and turn to courts. As was be expected, the legal battle between the Zamindars and the state governments took an unduly long time. When the Zamindars ultimately lost the battle, they turned to other delaying tactics by refusing to hand over land records and other related documents. These delaying tactics apart, even the legislations enacted were full of flaws, and the Zamindars soon picked up the loopholes in these legislations. Perhaps the biggest loophole was the one pertaining to the permission to obtain land for personal cultivation. The Zamindars could even evict tenants for this purpose. Personal cultivation was defined loosely to include personal supervision by the Zamindar or members of his family. The policy laid down in the first plan was that Zamindars could assume land for personal cultivation up to the ceiling limit, and tenants could acquire permanent and heritable rights in land only over and above the ceiling limit. With a view to bringing about uniformity in the definition of personal cultivation as adopted in different states, the second 5-year plan specified that personal cultivation should have 3 elements. Number 1, risk of cultivation. Number 2, personal supervision. Number 3, labor. Though the official documents claim that Zamindari has been completely abolished, yet the fact is that it has only changed its garb. The previous Zamindars have cultivation is done with help of hired agricultural labor. They are now designated as big landowners and along with the rich peasantry have formed a new and dominant class of rural capitalists. Despite these observations, there is no denying fact the after independence exploitation and oppression of tenants and actual tillers of the soil has declined steeply and the feudal rural structure has crumbled down. Tenancy reforms. Under the heading tenancy reforms, the following three measures are discussed. Number 1, regulation of rent. Number 2, security of tenure. Number 3, conferment of ownership rights on tenants. Now let us discuss about regulation of rent. In the pre-independence period, the rent charged by zamindars from the tenants was exorbitant. The British government was merely interested in its share and consequently gave unlimited powers of suppression to the zamindars to squeeze the tenants. It has been estimated by Brij Narayan that in Punjab as much as 80% of the produce was extracted from the tenants by the zamindars in the form of rent. In Bombay province, the rate varied between 40 to 60%. According to H.D. Malaviya, in the country as a whole, the rate varied between 43 to 75%. As a consequence, legislations were enacted after 1947 to regulate the limits of rents and reduce the burden on tenants. The first 5-year plan stated that maximum rent should be fixed at 1/4 or 1/5 of the total produce. In Punjab and Haryana, fair rent is fixed at 1/3 of total produce. In Tamil Nadu, it is 40% of gross produce for irrigated land, 35% where irrigation is supplemented by lift irrigation and 33.33% in other cases. In Jammu and Kashmir, landowners have been divided into two categories. Number 1, those holding less than 12.5 acres and number 2, those holding more than 12.5 acres. For the farmer, the fair rent has been fixed at 1/4 of total produce for wetlands and 1/3 for dry lands. In Andhra, areas of Andhra Pradesh, fair rent is 30% of total produce for irrigated land and 25% for dry land. However, legislations fixing maximum limit of rent have been often violated. Because of the strong socio-economic and political hold of the landowners in the countryside, they have been able to extract considerably more rent from the peasants than the rent fixed by the legislations. Then second one, security of tenure. To protect tenants from ejectment and grant them permanent rights in land, legislations have been passed in most of the states. Legislation for security of tenure had three essential aims. Number 1, ejectments do not take place except in accordance with the provisions of the law. Number 2, land may be resumed by an owner if at all for personal cultivation only. And number 3, in the event of resumption, the tenant is assured of prescribed minimum area. In all tenancy laws of the country, persons cultivating the lands of others on payment of rent, either in cash or kind or both, are treated as tenants. However, in some states like Uttar Pradesh and West Bengal, who pay rent by division of produce are not regarded as tenants. In some states, landowners were permitted to resume land right up to the ceiling limit, while in others the permissible limit was below the ceiling limit. Several states also passed laws requiring the landlord to leave a certain minimum area with the tenant as and when he assumes land for personal cultivation. For example, the laws in Kerala, Gujarat, Himachal Pradesh, Maharashtra, Karnataka, Orissa and Tamil Nadu provided that one half of the tenanted land should be left with the tenant. Laws relating to security of tenure can be implemented effectively only if correct and up-to-date land records are available. A person can claim that he is a tenant only if his name appears as such in the land records. However, it has been observed that in many states either no records of tenancy exist or in areas where they exist are incomplete and out of date. In states of Gujarat, Haryana, Maharashtra, Punjab, Rajasthan and Uttar Pradesh, there is a provision for annual revision of records. However, several tenants do not try to get their names recorded because of the danger of being evicted. In other states, for example, Andhra Pradesh, Assam, Bihar, Karnataka, Kerala, Tamil Nadu, Orissa and West Bengal, there is no provision for annual revision of records, which are usually brought up to date after long intervals. The records remain out of date for most of the time. Then third one is the ownership rights for tenants. It has been repeatedly emphasized in the plan documents that ownership rights should be conferred on tenants, that is, they should be made owners of the land they cultivate. Accordingly, some states have passed legislations to confer right of ownership on tenants. West Bengal, Karnataka and Kerala have received more success than the other states. In West Bengal, 14 lakh sharecroppers have been recorded under the Operation Barga. In Kerala, applications of 24 lakh tenants for conferment of ownership were accepted. However, on the whole, the progress has been very unsatisfactory. It has been estimated that as a result of laws conferring ownership rights on tenants in various states, approximately 12.42 million tenants have acquired ownership rights over 6.32 million hectares of land.